Hi friends, this is CMA Deepika Bhugra Prasad, Insolvency Professional. The code IBC 2016, while it has been tremendously changing the economic landscape within our country, it has also been squarely playing a pivotal role in improving the ease of doing business ranking of our country across the global stage. So friends, I once again welcome you to Insolvency Insights, a snippet series curated by me to delve into such important judicial pronouncements under the code IBC 2016, which have been changing and improving the economic culture across the length and breadth of our country. So, friends, let us today discuss one such landmark case. So, this is the case of MTech Developers Private Limited versus National Faceless Assessment Center, Delhi, and another, which was decided on the 15th of April, 2024 by the Honorable High Court of Delhi. On the basis of Section 31 of the Insolvency and Bankruptcy Code 2016, once the resolution plan came to be duly accepted, the bar created in terms of Section 31 of the IBC would apply. Honorable Delhi High Court in the instant case has held that any proceedings for assessment, reassessment, or recomputation initiated in terms of the faceless assessment procedure under Section 144B of Income Tax Act 1961, after the approval of the resolution plan, is contrary to the clean slate theory under the IBC. Let us see the factual background of this case. Now, the proceedings before the Honorable NCLT commenced upon the filing of a petition under Section 7 of the IBC. The petition came to be admitted on 12th of November 2020, and an order of moratorium came into effect from that date. The RP on 23rd of November 2020 informed the income tax authorities of the pendency of the proceedings before the Honorable NCLT and conveyed a request to lodge their claims in accordance with the provisions of the IBC. The resolution professional in terms of provisions of the Act of Income Tax 1961 furnished its return of income for the assessment year 2021 and 22 on 10th of March 22, declaring a net loss of rupees 9 crores 47 lakhs and 64,000. In CIRP, a resolution plan submitted by Messrs. Sarthi Constructions, which was accepted by the COC, was approved by NCLT on 15th of March 2022. The Income Tax Department issued notices under Section 144B of the Income Tax Act 1961 pertaining to assessment year 21-22 on 27th of June 22, as well as issued notices under Sections 143(2) and 142(1) of the Act. Let us see the findings and the rationale. The RP is required to issue a publication inviting claims from all stakeholders. He is required to collate the said information and submit necessary details in the information memorandum. After the COC approves the plan, the adjudicating authority is required to arrive at a subjective satisfaction that the plan conforms to the requirements as are provided in subsection 2 of section 30 of the INB code. Only thereafter, the adjudicating authority can grant its approval to the plan. It is at this stage that the plan becomes binding on the corporate debtor, its employees, members, creditors, guarantors, and other stakeholders involved in the resolution plan. The legislative intent behind this is to freeze all the claims so that the resolution applicant starts on a clean slate and is not flung with any surprise claims. If that is permitted, the very calculations on the basis of which the resolution applicant submits its plan would go haywire and the plan would be unworkable. So what is the decision of the Honorable High Court? The Honorable High Court held that it was expressed in SR Steel India Limited Committee of Creditors versus Satish Kumar Gupta by the Honorable Supreme Court, that Section 31, subsection 1 of the Code makes it clear that once a resolution plan is approved by the Committee of Creditors, it shall be binding on all the stakeholders, including the guarantors. This is for this reason that this provision ensures that the successful resolution applicant starts running the business of the corporate debtor on a fresh slate. The words other stakeholders would squarely cover the central government, any state government, or any local authorities. The fact that a resolution plan, once approved, would bring the curtains down on any claims pertaining to a period prior to the approval of the resolution plan is no longer res integra. The Section 144B of the Income Tax Act details proceedings for assessment, reassessment, or recomputation being initiated in terms of the faceless procedure of assessment as prescribed therein. Any effort to assess, reassess, or recompute could tend to lean towards a recomputation of liabilities, which otherwise stands frozen by virtue of the resolution plan having been approved. Such an action or recourse would clearly be barred by Section 31 of the IBC, which binds all creditors of the corporate debtor, including the central and the state governments or any other local authority to whom a debt is owed. A Section 144B action is what the Supreme Court frowned upon and chose to describe as the Hydra head, and thus being contrary to the clean slate principle which the IBC advocates. In the case of Dishnet Wireless Limited versus Assistant Commissioner of Income Tax, the Madras High Court sought to draw a distinction between voluntary and involuntary insolvency, as well as the fact that the department had not placed on due notice. Further, the Honorable Supreme Court of India, via its very detailed judgment dated 13th of April 21 in Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Construction Company Limited, has settled the law by stating that once a resolution plan is duly approved by the adjudicating authority under subsection 1 of Section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including the central government, any state government, or any local authority, or guarantors and other stakeholders. And on the date of the approval of the resolution plan by the adjudicating authority, all such claims which are not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceedings in respect to a claim which is not part of the resolution plan. 2019 amendment to Section 31 of the INB Code is clarificatory and declaratory in nature, and therefore will be effective from the date on which the code has come into effect. Consequently, all the dues, including the statutory dues owed to the central government, any state government, or any local authority, if not part of the resolution plan, shall stand extinguished, and no proceedings in respect of such dues for the period prior to the date on which the adjudicating authority grants its approval under Section 31 could be continued. So we conclude that the purport of Section 31 of the IBC stands conclusively settled. Upon commencement of CIRP, the petition is duly advertised in terms of the provisions made in Regulation 6 of the IBBI Insolvency Resolution Process for Corporate Persons Regulations 2016, and which would thus constitute due public announcement. The tax authorities, therefore, cannot sustain the invocation of Section 144B based on their own failure to lodge a claim within the stipulated time. The writ petition was thus allowed, and the impugned notices were quashed. So, friends, we conclude that the court's commitment to giving a clean slate to the resolution applicant to work on the company through the resolution plan is really showing in all the judgments and pronouncements being made by the honorable courts. So friends, I trust that you find this both engaging as well as enlightening. So for further insights into such pronouncements, please like this video and subscribe to my YouTube channel. So friends, thank you for being here today with me. This is Deepika B. Prasad signing off. We'll catch you in the next case. Thank you.